Does this seem familiar to you?
Hey everyone! Sometimes we enter the agreement, we rely on the information given by another person. We may trust their words or the way they say something to us. But what happens if that information turns out to be false? This is where the concept of misrepresentation becomes important in contract law. So let's begin with the basic question. What exactly is misrepresentation?
Misrepresentation happens when one party makes a false statement of fact, and the statement causes the other party to enter into a contract. In simple words, one person gives wrong information and the other person relies on that information given and decide to agree to the contract. If misrepresentation is proven, the whole contract becomes voidable. This means that the contract is not automatically cancelled, but the innocent party have the choice to cancel it. So now I'll explain the main legal requirements. First, there must be a false statement of fact. This means that the statement must be something factual. It cannot be just an opinion, advertisement exaggeration, or sales talk. For example, saying something is the best quality may not always count as misrepresentation because it may look good just for the sale talk. Second, the false statement must be made before or during formation of the contract. This is very important because the statement must influence the person before they agree to the contract. Third, the innocent party must have relied on the false statement. This means they entered into the contract because they believed the statement was true. If the person did not rely on the statement, then it is difficult to prove misrepresentation. The main remedy for it is rescission. Rescission means cancelling the contract and returning both parties to their original position before the contract was made. For example, if money was paid, it may have to be returned. In some cases, the innocent party may also claim damages. Damages means financial compensation for the loss suffered because of the false statement. Damages are more likely to be awarded in cases involving fraudulent or negligent misrepresentation. There are also more important cases that show how English law deals with false statement. In Oscar Chess Limited versus Williams, the seller gave wrong information about the year of a car. He genuinely believes it was true. The court treated the statement as a representation, not a contractual promise. This shows that the court will consider the knowledge and position of the person making the statement. In Bentley Production Limited versus Harold Smith Models Limited, a car dealer gave wrong information about a car mileage. Since the dealer had specialized knowledge and experience, the statement was treated more seriously and the buyer was able to claim damages. In conclusion, misrepresentation is important because it protects people from being misled into a contract. The key points are there must be a false statement of fact. The statement must induce the contract, and the innocent party must rely on it. If proven, the main remedies are rescission and also damages.
In English law, negligent misrepresentation is a false statement made carelessly that induces another person to enter into a contract and causing loss. It develops mainly through the landmark case of Hadley Bryan versus Hewlett. In this case, Hadley Bryan asked a bank for a credit reference regarding a company. The bank carelessly provided a positive financial statement, and Hadley Bryan relied on that statement and suffered financial loss when the company became insolvent. The court held that a person may be liable for negligent misrepresentations even without a contract if there is a special relationship between the parties. The remedies for negligent misrepresentation include rescissions. The contract may be cancelled and both parties restored to their original positions. However, rescission may be barred by affirmations, lapse of time, third parties' right, or impossibility of restitution. The claimant may also recover monetary compensation for losses suffered.
The Misrepresentation Act 1967 contains several important provisions that frequently discussed in the contract law. For example, Section 2.1, Section 2.2, and 3. Section 2.1 strengthens the protection of victims of negligent misrepresentation, while Section 2.2 allows court flexibility in awarding damage instead of rescission. And Section 3 prevents unfair attempt to exclude liability of misrepresentation.
So under Malaysian law, misrepresentation is governed under Section 18 and 19 of the Contract Act 1950. To succeed in a claim, the innocent party must prove that the statement was false, important, and relied on when entering the contract. The statement must also be about a fact, not just an opinion or future promise. So there are three types of misrepresentation, which is fraudulent, negligence, and innocent misrepresentation. So let's talk about the first one, which is fraudulent misrepresentation. It happens when a person knowingly makes a false statement with the intention to deceive another party. So this can be seen in the case of Tan Chi Chu and Ors versus Eastern Mining Metals Co. Ltd. In this case, the defendant made a false statement to persuade the other party to enter into a contract, and the court decided that the false statement used to persuade someone into a contract amount to fraud, making the contract to be voidable. So the second one is about negligence misrepresentation. It happens when a person makes a statement carelessly without checking whether it is true. So for example, an inaccurate information was given during a business transaction, and the other party relied on that information when making a decision. The court held that when the person makes a statement carelessly without checking whether it is true, they may be liable if the other party suffer loss after relying on that statement. This can be seen in the case Huang Woods Product versus Hong Leong Finance. Third one is innocent misrepresentation, which happens when a false statement is made honestly without fraud or negligence. This can be seen in the case Gemakota Enterprise Senyap Berhad versus Public Bank Berhad. Although the information given was inaccurate, the court found that there was no intention to deceive and no lack of reasonable care. So the contract could still be rescinded, but there was no fraudulent or negligence involved. So in Malaysian law under Section 19.1, a contract caused by misrepresentation is voidable at the option of the innocent party, and the main remedy is rescission, which means that the contract can be cancelled and both parties are returned to their original position. Besides that, under Section 19.2, the innocent party may choose not to cancel the contract and instead continue with it. In this situation, the innocent party can claim compensation so that they are placed in the same position they would have been in if the false statement had actually been true. In addition, Section 65 and 66 required parties to return any benefits received if the contract is cancelled, just to ensure the fairness. So in conclusion, the Malaysian law protects fairness in contracts by preventing parties from being misled into agreements and recognize fraudulent, negligence, and innocent misrepresentation, and provides remedies such as rescission and compensation to protect the innocent party. Therefore, honesty and accuracy of information are important in forming a valid contract.
The first difference, the Malaysian law is more statutory. English law rely more heavily on judicial decisions and the Misrepresentation Act 1967, while Malaysia provide a detailed statutory definition in the Contract Act 1950 under Section 17 and 18. The second difference is that the Malaysian definition of fraud is broader than the English law, as in Section 617 include that active concealment, promise made without intention to perform, act fitted to deceive. Another major difference concerns to the duty of the representative. In English law, there is generally no duty on the representative to investigate the truth of the statement. This principle was stated in the Norton versus Lord Ashburton, where the court held that the representative cannot avoid liability simply because the other parties could have discovered the truth. However, in Malaysian law, under the exception of Section 19, Contract Act 1950, the contract may not be voidable if the representative could have discovered the truth with the ordinary diligence. English law provides stronger protection through the Section 2(1) of the Misrepresentation Act. Once the claimant proved the statement was false, the burden shifts to the defendant to prove reasonable ground of belief. Malaysia has no equivalent statutory provision. Therefore, Malaysian claimants generally bear the burden of proving negligence themselves. The last difference is based on the remedy of innocent misrepresentations. In the English law, damage may sometimes be awarded to innocent misrepresentation under the Misrepresentation Act 1967. In Malaysia, innocent misrepresentation usually only allow rescissions and restitution.
Let us consider a scenario involving a university student, tenant, and a landlord. The landlord assured the tenant that the utility fees are all included. Let's look at the real-life video.
Wow, so nice!
So as you can see, the unit is ready to move in.
So rental is just 900?
Yes, everything included and no extra charges.
Oh my god, that's so good. I'm down. Like, let me sign it. Yes. Hello? I thought all the utilities are included.
Only basic utilities are included. You should check the contract carefully, right? Now that we have seen how the landlord's false promise about utilities created a problem, let's explore the legal side. In contract law, this situation is called fraudulent misrepresentations. That means someone made a statement they knew was false or didn't care whether it was true, just to get the other person to sign. In law, the tenant has a defense. She can ask the court to cancel the contract. This is called rescission, and even claim damages for the losses caused by the fraud. For example, paying unexpected utility bills could be claimed back. Under English law, cases like Edgington and Fitzmaurice shows that knowingly lying in a contract is fraud. The courts allowed the victim to undo the contract and recover losses. And there's also the Misrepresentation Act 1967. Section 2, subsection 1 of this act says that if someone enters a contract because of a false statement, they can claim damages as if the misrepresentation was fraudulent, unless the person who made the statement proved that they honestly believe it was true. In other words, the burden is on the landlord to show he wasn't lying. This makes the tenant's defense even stronger. In Malaysia, Section 17 of the Contracts Act 1950 defines fraud. Courts have decided cases like Keng Chulian and Wong Tak Tong, and Tara Rajaratnam and Datuk Jagintasik, where promises made without intention to perform were treated as fraud. That means the contract is voidable. The tenant can choose to walk away. So, what's the lesson? Always get promises in writing. Don't rely on verbal statements like utilities included. Ask the landlord to list exactly which utilities are covered in the tenancy agreement. That way, you protect yourself from misrepresentation. Another important step is to seek advice before signing. Don't feel pressure to agree on the spot. Show the tenancy agreement to a trusted senior or even a legal aid clinic. A second opinion can help spot unclear terms or hidden costs that you might miss. Remember, contracts are serious, so it's always safer to get advice first.
Contracts are part of our everyday lives, especially for students. From renting accommodation to signing gym memberships, many agreements are made based on trust and verbal promises. However, problems can arise when false or misleading information is given before a contract is signed. In this scenario, we will demonstrate how misrepresentation may occur in a gym membership agreement and how both English law and Malaysian law may protect the innocent party.
Hi, would you like to join our gym? We have a special student package now.
Oh, okay, not bad, actually.
If you join now, you can cancel anytime, no hidden fees.
Okay, on.
Okay.
Sign now straight away.
Sure.
Hey, miss.
Hey, yes.
You're a receptionist, right? I would like to cancel the gym membership.
But you have signed a contract for 12 months. To cancel now, you need to pay the 800 ringgit penalty fees.
This situation may involve misrepresentation in contract law. The gym salesperson told the student the membership could be cancelled anytime. However, the contract actually included a 12-month lock-in period and an 800 cancellation fee. The student relied on this false statement before signing the contract. This is likely negligent misrepresentation because the salesperson carelessly gave inaccurate information. However, if the salesperson knowingly lied to persuade the student to sign, it may amount to fraudulent misrepresentation. Under English law, a person may cancel a contract if they were misled into signing it. In the case of Hadley Burn and Co. and Partners, the court recognized that businesses have a duty to provide accurate information. The gym staff told the student they could cancel anytime, even though the contract said the opposite. The student trusts the salesperson's word before signing the agreement. The law does not always allow businesses to rely on fine print if they give misleading information first. Therefore, the student may be able to rescind the contract or claim damages, which could remove the 800 cancellation fee. In Malaysia, this situation may fall under the Contract Act 1950. If the salesperson intentionally lied about the cancellation policy, it may amount to fraud under Section 17. If the statement was made carelessly without checking the contract terms, it may amount to misrepresentation under Section 18. Under Section 19, the student may have the right to rescind the contract because their concern was influenced by the false statement. This means the contract may be cancelled, including the 800 penalty fee. The student's failure to read the contract does not automatically destroy the claim, especially if they reasonably rely on the salesperson's statement. This situation may amount to negligent misrepresentation because the inaccurate statement influenced the student's decision to sign the contract. Protect yourself. Always read contracts carefully, ask for important promises in writing, do not rely only on verbal statements, check cancellation clauses before signing. The student's failure to read the contract does not automatically destroy the claim, especially if they reasonably rely on the salesperson's statement. This situation may amount to negligent misrepresentation because the inaccurate statement influenced the student's decision to sign the contract.
From all this, we hope you now have a better understanding that misrepresentation is more common than you think. Even in our daily life, we can easily mislead without realizing it. Contracts are not just papers for lawyers and businesses, they will affect you too. So, what you can do? First, always take a moment to read carefully before you sign anything. Pay attention to any promises being made and whether they match what is actually written in the contract, and ask if something doesn't make sense to you. Knowing some basic law will make a big difference. Remember, this is not just for lawyer, it's for your life. Stay alert, stay informed, and don't let misrepresentation catch you off guard.